One of the things I end up talking with clients about regularly is whether it's better to petition for someone as a spouse or as a fiancé. This comes up regularly when someone is in a serious relation with another person who's overseas and they know that they're getting close to that decision point, but they're not sure what's going to work better logistically. And I will be honest that this is a very circumstance specific thing. And the first question I generally ask that person is, what are your priorities? Are your priorities that the person be here as soon as possible? Or is it your priority that the person be a permanent resident as soon as possible? Another common consideration is whether there are already minor children involved on the part of the intending immigrant, the person who's going to be petitioned for. These are often deciding factors in these cases, but I want to talk a little bit about where the pros and cons lie for each process, and then a separate process that exists to sort of split the difference between the two. So in the case of someone who is petitioning for a spouse, we're envisioning a situation normally where the couple has met in the country outside the United States, where the intending immigrant lives, although they could travel to a separate country if they wish. They've gotten married there, and now the U.S. citizen or U.S. permanent resident is filing a petition. In the case of a permanent resident of the United States who's not yet a citizen, but who wants to petition for this person, a spouse petition is really our only option. There's no fiancé of a permanent resident visa category. So that's a deciding factor in many cases. But in these situations where someone is already married and petitioning, the benefit is that there will be a petition process that'll last often about a year, sometimes less, sometimes a little more, and then a process of going through a U.S. consulate outside the United States, after which the person enters, and from the time that they enter, the person is then a permanent resident. This can also be better if there's a specific location outside the United States where we want the wedding to occur. Another benefit in this category is if there are children who are approaching the age of 18 or 21, key ages, it can sometimes be preferable for a wedding to occur before that minor child reaches age 18, or for a petition to be filed before the child reaches age 21 in order to preserve quicker treatment for that minor child, more flexibility for them to be able to petition independently. One important thing to keep in mind is that if we are going to be doing a spouse petition and there are children under age 18 involved, we would need the wedding to occur before any children reach the age of 18. And so if we have children who are, say, 17 and a half and we're trying to pick a date for the wedding, we would want to take that into consideration. Once that's done, though, another factor to consider in this process of a spouse petition is that if there are dependent children who we're going to be petitioning for and the petitioner is a U.S. citizen, then each child is going to require a separate petition. If the petitioner is a permanent resident, the downside is the process is likely to take longer. The plus side is that the petition can be done one time for the parent, and the children can be included as derivatives, meaning that they don't require separate petitions. But these are all considerations that we take into account and differences between the two categories. Another thing to take into consideration when looking at a potential spouse visa petition is the timing at which the person will be able to become a permanent resident. Another consideration to take into account for a spouse petition is just the sheer burden of one process versus another in terms of paperwork and time invested in doing the process. There's something to be said for doing a process and having it be over. The spouse visa process is what we generally consider a two-step process. And what we're going to talk about next, the fiancé visa process, is better thought of as a three-step process. So now we'll get into that a little bit. When we're looking at a fiancé visa petition, again, this is an option that's only available to people who are marrying U.S. citizens. If you're a U.S. permanent resident looking to petition for a fiancé, unfortunately, you can't do that right now. You would have to first naturalize, become a U.S. citizen, and then you could do that petition for your fiancé. The next thing to keep in mind about this is how we would treat any minor children. So if your fiance is someone who already has children who are under age 21, there's a bit of an interesting difference here between the fiancé visa petition and the spouse visa petition. There's no specific requirement that your marriage occur before the child is 18. So if we have a child who's, say, 19, 20, but not yet 21, and we are filing a petition, there may still be room to work with that situation, even if the marriage has not taken place yet. Another difference that we look at regarding children of fiancés is that in this scenario, whether you're a U.S. citizen or a permanent resident, there's still just one petition you have to file. And in that petition, both the fiancé and their minor children are able to enter on visas related to that same petition. So in terms of overall administrative burden, amount of paperwork, and often amount of cost, that can help keep things under control a little bit better. One of the things to keep in mind when we're talking about this process is exactly how it works. So a spouse visa petition process tends to be two steps. There's a petition that's filed called an I-130. That gets processed and approved by USCIS inside the United States. And then there's a separate process we go through with the Department of State to have that visa issued at a U.S. consulate outside the United States. Those are the two main administrative processes to go through. With the fiancé visa process, we have those first two steps as well. There's a petition filed, in this case an I-129F is the form we use, and once that's approved by USCIS inside the United States, it's again processed through the Department of State in order to have a visa issued at a U.S. consulate abroad. The difference is, once that visa is issued at a U.S. consulate abroad, the person then has to enter the United States on that visa. After entering the United States, they have 90 days in order to marry the petitioner inside the United States. So once you get off the plane, you better have a date set pretty quickly for when you're going to get married inside the United States. If it's a priority for you to have your wedding outside the United States, this is not the process for you. If it's a priority for you to have your wedding outside the United States, this is not the process for you. The next thing that has to happen is, once that wedding has occurred, there's an application for adjustment of status that gets filed. This is a step that does not exist in the spouse petition process that we talked about earlier on. The next step that has to occur after the wedding is the filing of an application for what's called adjustment of status. It's Form I-485. It's the actual green card application. In a spouse petition process where the spouse has gone to an interview at a consulate outside the United States, there's no requirement for this to be done. And so this is something that's a bit different about the fiancé visa process. It adds often a few months, sometimes a year or more, to the processing of the permanent resident status. This is a step that doesn't have to be done in the spouse petition process where a spouse is interviewed at a U.S. consulate abroad. And so this application for adjustment of status can add several months to a year and sometimes more to the administrative process that someone goes through before actually becoming a permanent resident. During that time, they're still authorized to be in the United States, still can have work authorization, and so it's not necessarily an uncomfortable period. They can even request permission to travel outside the United States, but they're not yet permanent residents, and so that's something to keep in mind. Going back to the topic of children, when we talk about children of fiancés who have entered the United States and married a U.S. citizen petitioner, there are certain privileges that they get. So in this situation, whereas in other categories we would generally worry very much about the child reaching age 21, this category for a child of a fiancé who is, the child is entered in what we call the K3 category and is now applying for adjustment of status, it's actually much more flexible in terms of their age and at what point they have to do certain things. So that can be a benefit that the K3 visa holder, the minor child of a fiancé, will receive. Overall, as you can see, there are multiple differences between the spouse petition, the fiancé visa petition. Largely comes down to what your goals are, what your timeline is, whether it's more important to you to have someone in the United States sooner, or whether it's more important for them to have green cards sooner. Often the time is unpredictable for these. I don't make promises about how quickly one or the other will be processed, but a fiancé visa petition typically is going to take perhaps a little bit less time than a spouse petition. It's unpredictable though. But if someone says, no, I need them here as soon as possible, we'll often try to see if a fiancé visa petition might fit their other priorities as well. The other difference that we talked about for these is the way in which minor children are treated, whether they require their own individual petitions or whether they require just one petition for the whole family, and then at what point we start worrying about their ages. The other difference we talked about for minor children were whether they are going to require separate petitions or whether the whole family can use just one, whether or not we need to worry about their ages at the time that a wedding occurs or at the time that they enter the United States, and exactly the administrative process that they have to go through. Then that administrative burden is the other big difference between the two. The number of applications that get filed, number of petitions, the duration of the overall process. So these are important differences to keep in mind. I want to touch on one thing that lies somewhere in between a spouse petition and a fiancé visa petition. It's an interesting provision in the law in theory, and that is what happens for the spouse of a U.S. citizen who is looking to enter the United States as soon as possible. Is there something that exists to try to help that spouse of a U.S. citizen who's outside the United States but trying to get in, to try to get here a little bit faster? At one point, Congress came up with a solution for this, again, in theory, that often doesn't work as well in practice. The idea is, if I'm married to someone who's outside the United States, I'm a U.S. citizen, and I want to petition for this person, I can file the I-130 petition. That starts them on the road to permanent resident status. But I can also file a form I-129F. That's the form that we use for fiancés, but it's also possible to file it for a spouse who has a pending I-130 petition. In theory, at the time that this was implemented, the I-129F would be processed faster than the I-130. Once that was done, the person could then enter the United States using that I-129F approval and a visa issued based on it, and then wait for the approval of the I-130 inside the United States. It's turned out now that the processing time for the I-130 on one hand and the I-129F on the other hand are very close. And so it's very hit or miss whether we actually see someone in that situation get here any sooner. It's still something that we can try if we want to try everything at our disposal to try to get someone here as soon as possible. But it's also not something that you would take to the bank, so to speak. That's an overview of what you ought to consider in choosing between a spouse petition or a fiancé visa petition. If you have questions about that, I can be of assistance to you in any way. Please don't hesitate to let me know. Thanks very much.